Yes.
Lordship, 439 application method. The charge sheet has been filed. This state method record may be called for.
Search it is filed under section 4 of the POCSO Act.
4 of POCSO. Yes, ma'am. Information has been made to party. Notice should go, my lord.
Heard, Mr.
PH for my lord.
Learned counsel for the accused, and also heard Mr. K.K. Parasar, learned additional PP for the state respondent. This application under section 439 services prepared by accused Amit Ravi Das, who has been languishing in jail as of in connection with non-mati PS case number 215 of 2023 under section 341, 354, 323, 352, 511 IPC, read with section 4 of the POCSO Act since 14/7/2023. Having heard the submission of learned advocates of both sides, it is provided that Resty shall call for the scan copy of the record in the learned court below, and also notice be issued to the respondent number 2 by registered post and also by usual process within 2 days from today. List the matter on
512.
5/12.
Item 3. This is 413 application. There is a charge sheeted method under section 376 and section 6 of the POCSO Act.
Section 6.
6.
Okay.
And out of the 7 witnesses, 5 have already been
Examined.
Yes, Lordship.
Scan copy of the record and notice to the respondent number 2.
Lordship, the address of the informant is not clear. So if I may be allowed to take the steps to the PP.
Through
PP through the PP, Lordship. It is already given the village, Haripur, police station, Tamarhat. And then mobile
no,
number.
from where the PP will obtain the correct address.
The PP office can make it the same.
Okay.
To the, it can be
through the officer inside jurisdictional place. When?
512. I don't know. FSL report maybe you call for that. FSL is not. FSL report will be there. Charge sheet already. Lordship, the charge sheet was filed. FSL was not filed.
Along with CD.
So the charge sheet, the FSL was not filed. The charge sheet was filed.
FSL was not filed with the search sheet.
Yes, Lordship.
Now, whether there is any FSL report or not.
You have to still been engaged in that trial matter.
Okay, let the record come. We will see if it is not available in the record, then we will call for it.
All right. Item 4.
Sir, actually, Mr. 41123, affair case still section 21B of NDPS. So,
NDPS Act. Okay, let the city come.
Let the
city.
From
CD on when?
From Boko, Maladan, 28 Malad.
28.
Item 5.
May I please, Lordship?
Yes.
439 bill. It was arrested on 3/10/2023, Lordship, under section child marriage act. Affair is case number 12. Today is 46 days, Lordship. In the FIR, Lordship,
Section 6 of the POCSO Act is also there.
Lordship,
Okay, same order like this, item number 2.
Lordship, POCSO not attack, out of their law affair, they solemnize their marriage. At that time, her age
We will
was
see the case there.
17 years old. Lordship, it is clear in the FIR part, Lordship, 17 years. But this allegation not raised from the family members, from the victim, neither her family members, Lordship. One VDP president has raised this.
So,
lost this
anyone criminal case can be filed any person.
Lordship, if you go through the section child marriage, violation of child marriage, then punishment is up to 2 years.
Section 6 of the POCSO Act is there.
Lordship, the husband and wife, they teaching the.
We'll say. Let the city come.
And also the try annex one prescription.
What prescription?
At present, I have 6 years old baby suffering from illness, Lordship.
Mm.
At this present, parents of the
6 years
petitioner is very required, Lordship. If possible, Lordship.
Okay, we will fix a very short date. When, Mr. Parasar?
Support, on 24th,
24. Okay, but notice has to go to the
yes,
informant.
notice has to go, and
Same would like to.
he annexed the birth certificate as per birth certificate date of birth is 2004, July 2004.
Mm.
As per FIR, marriage is in 2021. So definitely 17 years,
17 years. I'm admitted to 17 years, Lordship.
Mm.
The
So
land of possession is
section
considered.
section 6 is not attracted according to you.
Yes, Lordship.
How?
They are passing their life as husband and wife, Lordship. It is
Hmm.
not also raised from a
Is
family
it
member.
permissible?
Victim.
Is it permissible under the law?
Item number 6.
Apply.
Entry by custom officer.
Hmm.
So at this case, offense report may be called for.
Search it offense report submitted.
All of serious. Can copy may be called for marriage. Sorry.
When offense report was submitted?
Let's see from 8
8.
2023.
Heard Mr. D. Bora, learned counsel for the accused, and also heard Ms. Deka, learned learned counsel appearing on behalf of Mr. S.C. Kair, learned standing counsel for the Customs Department. This application under section 439 service is prepared by accused Santanu Lakkar, who has been languishing in jail Azuti in connection with Customs case number 02CL NARC ASGAU 2023-24 under section 22C of the NDPS Act since 7/8/2023. Mr. Bora, learned counsel for the accused, submits that after completion of investigation, the investigating officer has filed offense report against the accused. Accordingly, it is provided that rest shall call for a scanned copy of the record from the learned court below, fixing the matter.
112.
Object.
Item 7.
Rightly, my lord. For 39 bail application, my lord, with a 36 this my lord. The lordship be pleased to see the affair, my lord, at page 9. Section 8 of POCSO is there, my lord. Actually, my lord, out of enmity and rivalry, my lord, both the houses, informant and the petitioner's house, very immediate, my lord, to each other, my lord. And there is a dispute, my lord, between them regarding wall, my lord. Since 7 years back, my lord. Otherwise, my lord, allegation is false, my lord.
Item number 2. So notice has to go to the respondent number 2, and we will call for the scan copy of the CD
CD.
along with the statement of the victim girl recorded under section 164 CPC.
My lord, short date will be given.
When, Parasar?
kilogram, 28,
28.
Item number 8.
8 vigilance. Not this matter, not the same FIR, my lord, there is another case pending, my lord, item number 17, wherein my learned senior friend Mr. Didas is appearing. So, my lord,
all these were court cases just to heard this matter. But I have been told by the learned counsel, Mr. Kyle, that is on the way, the CD, the report. The report which you have sought for. This NDPS, it's the same one FIR, which I projected before your lordship that there are 2 which was granted bail. All these 4 was taken together. And I found one judgment of this court, my lord. I think Mr. Bora, Anshon Bora appeared. He is with me, but he is in Mizoram. He has given me one judgment of this court, your lordship. 20 days, 16.6 grams, but your lordship has considered only basis 67. That your lordship has detailed. I have got that particular judgment with me, order. So I will just place, if your lordship just want to hear it, I can just place this matter.
Okay, let Mr. Kyle come then.
Yes, yes. I just made a photostat copy of the three judgments. One is Amit Jain, where the learned trial court has granted. One is Mr. Bhatia, where also he has been granted. All these four were taken together. And one of your lordship's order.
70 pages.
Let Mr. Kyle come, my lord.
So item number 10.
My future lordship, this is 438 bail application lordship. Matter is pertains to child marriage lordship. FIR is page number 11 lordship. And party part is 12 lordship.
So section 6 and 17 of the POXO Act is also there.
Yes, lordship, my humble prayer is before
Okay,
your
let
lordship.
notice go address is this and CD.
Lordship, my humble prayer before your lordship. Victim is 8 months pregnant lordship. And in this situation, it is very difficult to move without his husband lordship. This is my humble prayer lordship.
We'll consider it.
Yes,
Let the CD come.
yes, lordship, and the
CD on when?
in between lordship interim protection and city
South Salmara Mala 28 minutes.
28.
information extend the lordship.
Pardon?
But the lordship, there is no relatives of information.
15 years
Okay,
girl
to
Mala
the
6 months pregnant. This is the pathetic condition. Mala.
Lordship, we have
Fine,
annexed.
No, the notice will
injection
go to
card
the informant,
informant is
Shamsul
decreasing.
Haq. Like this item number 2. Same order.
Lordship,
CD with his statement of the victim girl recorded under section 164 CFC.
Item number 11.
May I please your lordship?
Yes.
My lord, this is a 438 application, my lord. My lord, the present petitioner, my lord, has initially made an accused by of an FIR, my lord. The initial FIR, my lord, may be pleased to find is that, my lord,
That affair is at page number
my lord, that FIR, the initial FIR is at page number, my lord.
25.
Yes, my lord. 24 is the translated and 25 is the vernacular. Has been lost by some of the beneficiaries, my lord, for the purpose of, my lord, sanctioning of loan for the establishment of dairy farms as per the, my lord, government of India's policy, my lord. And my lord, what has happened? These beneficiaries has lost the affair naming me, although I am not a bank personnel or no involvement in my regard, my lord, in this regard regarding sanction of the loan amount. Now, my lord, what has happened after this affair had been lost? I approached before this honorable court, my lord, and this honorable court was kind enough, my lord, to give me the interim protection, my lord. My lord may be pleased to find the order is at page 28. My lord, the protection at page 29, my lord, in view of the above, it is provided that the event of arrest of the petitioner, namely so and so, in connection with the enlarged on bail of rupees so and so, my lord.
No,
and-
that is a different affair.
No, different affair, my lord, but belongs to the same loan, same issues, my lord, but the informant is different. Some beneficiaries has lost the affair. Now, my lord,
No,
they-
no.
my lord.
We are not concerned with that order.
No, my lord, why I am bringing into the notice of my lordships, my lord, is that
No,
the-
here the allegation is made by another person.
another person, my lord, by the regional zonal manager of the entire, my lord, of the zone, my
No,
lord.
no. This is not by the regional
No,
manager.
this is by, yes, my lord, this is by the beneficiaries of the loan. They have said
Yes.
that they have not got the, they have not got
So
the
you have
sanction amount.
granted bail in another case lost by another person. How that order is
No,
relevant
my
here?
lord, why I am, my lord, respectfully submitting before my lordship is that the loan amount which has been alleged that I have siphoned or some involvement is on my part, my lord, is the same loan amount which is connected with the present affair, my lord, which had been lost by the, my lord, regional zonal manager. My lord may be pleased to find the present affair in which I am seeking bail in this petition. Starts at, my lord, page 30, my lord, page 30. My lord, why this affair had been lost, my lord? When I appeared before the investigating officer, pursuant to the, my lord, interim protection provided when my statement recorded, my lord, then the involvement of the bank person and bank official come up in the investigation, my lord. And then this affair, to save the skin of the bank official of the, my lord, concerned bank, my lord, branch, the general manager has lost the affair by a very, my lord, masterly drafted, my lord, and all the responsibilities has been, my lord, entrusted upon me. I am not a bank personnel, my lord, not a bank official. I have nothing to do with the document verification.
Okay, we will
or
see.
nothing. So, my
What
lord,
was your role?
yes, my lord. Yes,
Let
my
the
lord.
city come.
And my lord, some interim protection
No,
may
no,
be given,
no,
my lord.
no. You
Because-
have misappropriated 40
No,
lakhs
no,
of
my lord,
rupees.
that is the issue, my lord. I have not a single money has been transferred
We'll
in my
see if
account.
there
my
is
lord.
no material in the case diary, then we will finally protect
Then,
you.
my lord, just a one document may I bring into my lordship's kind notice, my lord.
Yes.
The page 37, my lord. Page 37 is the sanction detailed statement of the loan, how it has been disbursed, my lord. At serial number 13, 14, and 15 are the beneficiaries, my lord. And the my lord may kindly see these are the amount has been credited in their account. There is no my name is there, my lord, that I could siphon this amount or any role of me, my lord.
The
My lord.
investigating officer will definitely collect the bank
Yes, yes, my lord.
statement.
And I am also cooperating with the investigation of the
We'll
same
see.
same forgery. my
We'll
lord.
see.
Same forgery. Some protection, my lord.
No protection at this
My lord.
instance.
Oblige.
CD on when?
Belgaum, my lord.
Belgaum, yes.
28 months.
28. 28.
My lord.
So item 12,
Oblige.
Notice, my lord, will find at page 10, my lord. Before that, FIR starting from page 11, my lord. Special cells Delhi, my lord. Relevant part, my lord, starting from page number 13, last paragraph, my lord. This was registered under section 120, 419, 420, and 120B, my lord.
You are referring to page number?
Page number 13, my lord. The first document that I am referring is the FIR, my lord. Even the FIR starting from page number 11, relevant portion, my lord. Last 4 lines, my lord.
So where the occurrence took place?
Delhi, my lord.
Then how this court has the jurisdiction?
My lord can come to page number, my lord can come to page number 19, 20, and 21, my lord. Straight away come to page number 22. This procedural case, my lord, and two judgment of this, my lord judgment and Mr. Justice. So here judgment is also there, my lord. As the jurisdiction, my lord, as far as jurisdiction is concerned, our own High Court has already held that yes, there is a jurisdiction, my lord, and these two judgment, my lord, one judgment of my lords is also there, my lord. 41, this is in regards to the jurisdiction, my lord, and then page number 10 is the 41A notice, my lord.
Yes, Mr. Parasar.
But maximum is transit bill, in case of transit bill can be malad, but before that malad, I have to take instruction malad, because this is an offense happen through internet malad. They have siphon money through internet malad, banking malad. So I have to take instruction. I am appearing as a central government council here malad, for response number 1 malad.
My lord can just like to take you to page number 10, my lord. The date was given by the special Delhi Cell Police was yesterday, my lord. We have moved this application, my lord. We are ready to appear, my lord. Even 41A, they have specifically said that if I don't appear, my lord, we are ready to appear, my lord. Only for a limited purpose.
Now, what instruction you want to obtain?
But regarding the involvement of the petitioner,
Involvement, my lord, specifically I have mentioned, my lord can come to page number 4, paragraph number 5, how I apprehend.
No, from where you will obtain the instruction?
special cell Delhi police.
When you will be able to obtain the instruction? Monday?
On the Tuesday, because phone
No,
number is
you will only obtain verbal instruction. No.
no, I have to collect phone number is not available.
Here in this case, my lord, with utmost respect, my lord, since the day has already been passed, my lord, I am ready to appear, my lord, only for the transit purpose, my lord, since 41A notice.
Okay, well, we will consider your prayer. Let him
Tuesday,
obtain instruction.
Monday, my lord.
Monday.
My submission will be on Monday.
Heard Mr. A.S. Tapatar, learned counsel for the applicant, and also heard Mr. K.K. Parasar, learned standing counsel for respondent number 1. CGC, learned CGC for respondent number 1, and Mr. K. Boyso, learned additional PP for the state respondent number 2. Apprehending arrest in connection with IFSO, Special Cell, Sector Dwarka, Delhi, ID case number 268 of 2023, registered under section 419 420 120B IPC. This application under section 438 services prepared by accused Almas Bacha for grant of the privilege of prior stay. Mr. Tapatar, learned counsel for the applicant, submits that the applicant is ready to appear before the IO concerned, and as such, he may be granted transit bail so as to enable him to appear before the IO. Whereas Mr. Parasar, learned additional PP, submits that learned CCC submits that he may be granted 1 day time to obtain necessary instruction from the Delhi police. Having heard the submission of learned advocates of both the parties, it is provided that it is provided that Resisa leaves the matter on Monday so as to enable Mr. Parasar to obtain necessary instruction.
Item number 18.
Yesterday, thanks for 1 day. This is the information by
after some time, this file is not given.
Item number 19.
Yesterday, this matter was taken up.
Yes.
939 days on custody, NDPS, and
913 days.
yes, 10 witnesses completed. 939 days as on date. 10 witnesses completed, and out of that, Lordship, yes, Lordship will recall yesterday, Lordship had given me the opportunity to peruse the depositions of the 5 witnesses, because up to 5 we have got the depositions, and none of the witnesses bearing Lordship, the official witnesses, that is the informant, he only says that the co-accused had made a statement that this petitioner was waiting to receive the contraband. Only that much of involvement. That is the only allegation against him in the evidence against him. That is an extrajudicial confession, nothing beyond that. Other witnesses, they do not recognize him, none had seen him, he was not present, that is what is stated. All the others.
So at this stage, why should we disbelieve that official witness?
Actually, only that that piece of statement of the co-accused.
Hmm.
He relies on only the statement of the co-accused and an extrajudicial. But whether lordship finally, even if the entire evidence is taken into account, whether only on that basis the petitioner can be convicted, because lordship 37A while 37(1) while
That's all right. But from where he was arrested? From the place of occurrence?
yes, that is. Yes, that is what they say, that he was waiting to receive, and from there he was arrested. And my explanation is that he is a contractor by.
No, madam, you see, we are, can this court appreciate that aspect?
Lordship.
Can we appreciate that aspect at this stage? That is the business of trial court. At the end of trial, the
I
court will
understand,
consider
Lordship.
it.
Lordship, but also 37, as per 37, for purpose of granting bail, whether there are reasonable grounds to believe that the accused has not committed the offense.
Hmm.
And in view of the evidence which has been led so far by the prosecution, in view of that, Lordship, probably there are no reasonable
Ground
yes,
for believing that he has not committed the offense.
Lordship, yes.
Yes, so Mr. Question?
Lordship, 10 numbers of witnesses already being examined, and the trial is pending. Here, Lordship, the CD part is not available here, and Lordship, only the initial depositions and the order sheet is available in the LCR, Lordship. And so otherwise, if, as per the section 37, we have to go by that.
37?
Lordship.
Forwarding report only indicates that he was arrested while he was, because he was waiting to receive the contraband. At page
And he was identified by the other accused persons
Yes, sir.
at the place of occurrence, where the accused persons are supposed to deliver the contraband substances to the accused.
Other accused persons has made that statement. That is what I have been submitting. They have made a statement that the petitioner was waiting to receive the contraband. The other co-accused persons have made a statement. On that basis, he was arrested. But none of the prosecution witness, they have not been the witnesses who have been Caesar witness, they have not been able to identify him. All say he was not present there.
Okay, anything
Lordship,
on
the
yeah,
20B2C, Lordship, the commercial quantity, and the affair reflects from the statement of the accused itself, and he was apprehended from the place of occurrence, Lordship. So it's a case of parallel, Lordship. They are associated.
Madam, you were referring to evidence of PW?
PW4.
PW4.
That's part PW4, second page, if your lordship peruses. Second paragraph, he says, accordingly, I along with SI so and so, went to the Kotkoti Naka checking point near SBI branch at 4:30 p.m. At about 5:30 p.m., we intercepted a truck bearing registration number so and so. On searching the said truck in presence of SDPO Bokazal and independent witnesses, namely so and so and so and so, we recovered 60 packets of suspected ganja wrapped with polythene, of which 16 packets were wrapped with black color polythene and other were wrapped with transparent polythene, which were kept concealed in the backside of the truck. Then I seized one digital weighing machine from one nearby one shop for weighing the recovered ganja in presence of witnesses. Exhibit so is the seizure. This is so far as relating to seizure. Seizing the lordship, the last paragraph in that page, same page. During interrogation, the driver of the seized truck, Ranjit Singh, confessed before me they would deliver the recovered suspected ganja to 1 Sri Udip Dotto at Silonizan. This is the only statement which is against the petitioner. The driver of the seized truck confessed before me that he would deliver the recovered suspected to Udip Dotto. We found Udip Dotto near Gorampani Reserve.
Whether the forwarding report of the present accused is available in the record?
Lordship, we forwarding report.
Yes.
Yes, we have enclosed it in our petition.
At page
At
number?
page 18. Starts at page 17. Annexure 2. Start. And the grounds of arrest at page 18.
We will see. Heard Ms. Deborah learned counsel for the accused, and also heard Mr. Kaboiso learned additional PP for the stateless member. Argument concluded, order reserved.
Item 13.
Wait, please, your lordship. In this case, my lord, this is the second bail application. Earlier, rejected by your lordship, my lord. On two new ground, my lord, I am placing this petition. First of all, my lord, the petitioner is the secretary of a cooperative society. And cooperative society secretary, the section 409 is not applicable to him because he's not a government servant. In that aspect, there is a judgment of our High Court. And second, my lord, regarding my lord, all the document which was regarding resolution of the the society was not placed before your lordship in the earlier occasion. So that we have annexed by way of additional affidavit.
with the permission of the court, my lord, that is before your lordship. Now, first point, my lord, your lordship kindly see 409. There is a judgment of the our High Court. Here in the case one only 409 is my lord registered. Only Honorable Justice K. N. Swikia's judgment. That's the NOC, my lord. Cooperative society is registered under the Cooperative Society Act, but these are totally private. These are the government has no control over that, my lord. In that aspect, there another judgment in the Supreme Court also, my lord. That is in respect of the employees, they are not getting salary, and they oppose this honorable court. That court asks that the honorable court pass the order to give them salary by the government, my lord, some remuneration. But I went to Supreme Court. Supreme Court said no. Cooperative societies, that under the cooperative society, they are not. There is no government control. Article 12 not been affected, that hence their petition were dismissed by the honorable court. So in that way, my lord, I'm submitting that is still clear that the 409 is not applicable to the employees of the cooperative society. Although that is in respect of the salaries, my lord, salaries and my lord, other increment. There are 9, 13, 14, and 22. That case, my lord, that is Korimbang District Milk Product Cooperative Union, my lord.
Which paragraph you have relied upon?
That is 9, 13, 14, and 22.
Uh, 13, 14, and
23, my lord. So that is in context of, my lord, that is the government has no control over that, my lord. And in fact, my lord, employees of the societies are not also civil posts, my lord. Purely their salary is being paid by the society. That is in respect of law, my lord. But regarding facts also, my lord,
no. Where is the ratio here?
no, here, my lord, what I want to say, my lord, because of this, by this judgment, my lord, the employees of the private societies, they are
No,
not,
where
my
it is stated?
your lordship will find, my lord.
Because in paragraph number 23, the
No,
court
no,
has
the
relied
23 is the
upon
quoting of the
another
another
judgment.
13, my lord,
13.
my lord.
So this is a one of the ground that 409 in respect of the Secretary of Cooperative Societies
Here, my lord, that only
is not
409
detected.
409 is there. Other section is not there.
Mm.
Only 409.
Mm.
Your lordship kindly see.
Oh, that's all right. Oh, what is the other ground?
Other ground, my lord, your lordship kindly see that FIR page 20.
Is
Page 20. Page 20, man.
yes.
This is a complaint, my lord, lodged by the your lordship kindly there is an inquiry, my lord. There is no search one. Has your lordship got it? Search one. There is no joint account in the name of chairman and secretary of the financial transaction society handed over the so. Two, the secretary running the office of this house, which is generally public, suffering from lot. The proper weightage of the bag of the rice never maintained. Almost 650 gram in each bag is this not delivered to the dealers. 4. Commission of the MDA rice in the dealer never issued by him. He has single account for transaction. 5. The secretary used to take rupees 13 per quintal from their agent and carrying, which is totally illegal. Now, my lord. Second para, my lord. This complaint has been filed by the board of directors, my lord, who are newly elected, my lord. They are yet to take charge, my lord. Charge 1, the matter is related to the Cooperation Department. Charge 2, the matter is related to the Cooperation Department. Charge 3, we obtained statement of 12 numbers of fair price shop dealing tag as GPSS. In the statement of fair price shop dealer state that society used to curtail 4 kg of MDA rice from the allotted quantity of the dealers and plea handing the shortage and also charge additional rupees 13 to the 14 per quintal from the dealers and labor charge allotted to NFSR rice. Also stated that secretary charge extra commission from the fair price shop for dealing the maintenance of the charge. Therefore, the charge number 3 and 5 are to be substantiated. Charge number 4, in the statement which was given by the dealing in the times of quantity, equally that they have not received any transportation cost communication against MDS till today. Therefore, the charge level against the seed society appeared to be substantial. So, charge number 3 and 5 there, my lord. Your lordship kindly see page 25 and 24 of the my that is answer, my lord.
No, Mr. Mohanto, you see, section 409 not only deals with about the public servant, but it also deals with, speaks about a banker, merchant, or
My
agent.
lord, we are not banker, we are not merchant, we are not
Agent.
agent.
Is it correct proposition?
Yes, my lord.
That you are
This
not
is
the
a
agent?
cooperative society, they are owned, my lord. They are cooperative society and the societies, my lord, they are dealing with the government, not by the persons. There is a governing body, my lord. We are not getting anything from my lord government. My lord. So that's why, my lord, in the judgment is very clear, my lord. 409 is not attack. Your lordship kindly see that.
No, that is in respect of public servant.
No, 409. Your lordship kindly see. That's why I'm submitting 409, my lord. NOC 9. 409.
No, there it is held that whether a public servant.
Then your lordship kindly say that's why
Secretary
409 is not a
Cooperative Society is not a public servant.
Then your lordship.
Within the meaning of section 21.
Then 409 is not
the-
effect. That line is there, my lord.
Which one? Yes, 409 public servant.
No, 409.
We agreed that you
409
are
is
not
my lord
public
offense.
servant. But going by the definition of section 409, can it be said that you are not the
No,
person entrusted with the property?
No, since no other section may be come, my lord. That 409 will not come. 409 will not come. Other section may be come. Now, my lordship kindly see, these also, my lord. These are the charge, my lord, which is level against me. I have an answer to that, my lord. Your lordship kindly, page 25, my lord. Page 25. there is a deputy commissioner direction, my lord. There is a minutes of the meeting with the deputy commissioner, and my lord, that is 100 rupees per, my lord, quintal. That can be, my lord, charged. There is no bar, my lord. So that's why that's cooperative society did not done any wrong, my lord. And only, my lord, your lordship, my lord, while passing the judgment, passing the earlier order, one, my lord, order was that, my lord, some amount of money has been transferred to my account. That was the only line I have signed, my lord. That is also not reflected in the FIR, my lord. But I have an answer to that also. I have annexed everything.
No,
my lord.
Mr. Monto, you see, only going by the FIR, I have not passed the order. I have produced the case diary.
Exactly, that's why in case diary, my lord.
No,
that-
the way
that-
you have submitted is
No,
that
no,
without
what I am going to submit, my lordship, kindly hear me for a moment, my lord.
Hmm.
I am going to submit, my lord, that the order, your lordship, I have an answer to that also, because after the period of the case diary, your lordship has been, my lord, passed the order. But in case diary, that answer also, because all the document was not placed before your lordship. Because yes, correct, it's my account, it was admitted.
No, whatever documents were available in the case diary, I have gone through.
Exactly, my lord.
Then
Exactly. That's why I'm
what
submitting.
documents you are referring to?
That document was not before the police, my lord. That all the documents, my lord, the societies, my lord. The resolution, my lord. There is a resolution, my lord. That resolution has to be placed either not by the petitioner in earlier occasion, also in the case diary, my lord. That's why I want to place, my lord. That is my case, my lord. That record was also not seized, my lord. If it is seized, then it is available in the case diary, but not seized. Only line I have seen, my lord. Your lordship kindly see that your lordship order, my lord. But that I have answered, my lord. Page 42, my lord. 11 para is page is page para 9, my lord. It para 9, my lord. Has your lordship got it? Page 46, my lord.
Yes.
It appeared from the case diary that IO has collected a sufficient incriminating material in support of the allegation made in FIR. The application has been running in the society from his residence and the witnesses examined so far implicated in the allegations made in the FIR, and investigations are going on, and appellant has been absconding. It is also appeared from the material collected in the case diary that the appellant has been operating single bank account and on several occasions had transferred money from the account of the society to his name. So in that respect, my lord, I will place, my lord, page 70, your lordship kindly see page 70, my lord. Affidavit, additional affidavit, my lord, I have filed, my lord. Page 70, my lord. There is a resolution of, my lord, that is 2/4/2023. Page 70, my lord. Resolution 4, my lord, has your lordship got it? May I read, my lord, page resolution 4?
Yes.
The chairman informed that the house that the family of the late Vishnu Prasad Debroy and the ex-secretary of the Cooperative Society has submitted an application. Application is read out to the house. It has been revealed that the application that a huge sum of money remained due to the Vishnu Prasad Debroy, and it has been paid for payment of the money. After threadbare discussion, the house decided to make a payment, but it is present that such much of money is not available to the balance sheet of the Cooperative Society. Further, the huge amount of money remained due to the Cooperative Society from the government. The house is decided to debt Vishnu Prasad Debroy will declare cleared up when the government pays the money to the Cooperative Society. The house also decided that Vishnu Prasad Debroy is no more, and the amount due to him will be paid to his widow, 2 sons, and a daughter of equal share. The amount due to the Cooperative Society from the government and the amount due to the ex-secretary Vishnu Prasad Debroy from the Cooperative Society have been mentioned in the balance sheet of the Cooperative Society. The house entrusted the chairman and secretary to the Cooperative Society with tax and make the payment. So accordingly, there is a resolution, page 7, your lordship kindly page 77, my lord. So there is a certain amount of money, 19 lakhs, which has to pay to the earlier secretary, my lord. He's my father. And then, my lord, his widow and other 2 sons, and daughter, my lord, file an application to the society. That is page 77, my lord. Page 77, my lord. Wherefore, release of recovery money from your Cooperative Society. Respected sir, so and so, so and so. With reference to the above, I inform you that my husband late Vishnu Prasad Devroy and expired on 30/6/2020. And after his expiry, we undersigned legal hire mutually decided that the recoverable money which has been shown in your balance sheet as a creditor will also be released from your cooperative society. In this view, I am submitting a here with a Xerox copy of the next clean certificate for your favor, your kind better information. Therefore, the fact is requested your honor will be kind to release and such amount early as possible. And add to more that also inform you that the details of such bank account mentioned here Lily Devroy, Musumi Biswas, Vishwadip Devroy, and Vikas Devroy. These are the 4 persons found, and ultimately, my lord, page 78, your lordship kindly see. Page 78. The branch manager, FX Banker, Ramakrishna Nagar, my lord. So, 4 equal share that was distributed to my lord, all the legal hires of the earlier secretary. I am one of them, my lord. So, that is why that amount has been credited in my account, my lord. So, that are not been placed before your lordship in earlier occasion, my lord. That's why I am submitting, my lord. And not in so reflected in the case diary also. And my salary also, my lord, deposited in my lord bank. So, in that way, my lord, some transaction in my account. That is my case.
Yes, Mr. Boysa.
So the CD reveals that there is some kind of transaction in the bank account estimated by my learned CD. And also, Lordship, there's an investigation is in progress, and some statement from the witnesses also Lordship recorded in the 160. Lordship, may kindly produce the CD. I have flag marked.
No. You verify this as his submission that he has a receipt which is due from his father, due to his father.
Lordship, that is not recorded. Only the part is that some transaction.
You see the bank transaction there.
Transaction details is there.
Here, page number 78. You examine it. You inform the court letter. After some time, sir.
Survey number 20, personal appearance.
Yes, madam. Is the case diary available today?
Today
Available. Is there any material in the case diary?
Worship statement of co-atheist implicated in that.
From the FIR, it revealed that some persons from Jharkhand were arrested with some imitation gold post, and they revealed that they have purchased from me.
So why the CD could not be sent on earlier occasions? Madam, no. Madam Das, you can communicate.
She was in LO duty.
LO duty.
And also transferred. Also transferred to Samu Juria.
Heard Mr. S.M. Abdullah P, learned counsel for the applicant, and also heard Ms. N. Das, learned additional PP for the state respondent. Pursuant to order of this court dated 16/11/2023, the IO concerned personally appeared before the court and produced the case diary before the court. Her personal appearance is dispensed with. You can go now. This application under section 438 is prepared by applicant. Procedural Haq and Nurul Hussain, who are apprehending arrest in connection with Samaguri PS case number 25 of 2023 under section 120B 406 420 34 IPC for grantor arrest. A rope noted case has been registered on the basis of an FIR lodged by SI Tilok Phukon of Samagori PS on 28/1/2023. Mr. Abdullah,
Lordship.
your name is not there in the FIR?
Well, there is, my lord.
There is.
There is, my lord. My name is there, my lord.
Which part of the
paragraph,
FIR?
my lord, in the second paragraph, my lord, in the bottom side, my lord, second paragraph. During the preliminary interrogation, the apprehended persons have shown us the house of the sellers and later identified.
Yes, madam. What materials are available?
Lordship, the statement of co-accused lordship implicated.
Can I see the case diary?
Yes, sir.
The essence of allegation made in the FIR dated 20/1/2023 is that
Section 406 and 420 may not be affected, Malak. I have not cheated anybody, Malak. The person who purchased there from Jharkhand, they knew Malak it was imitation gold, they purchased from us.
that acting on a tip-off, they have conducted search. No, the informant and other police personnel conducted search. No. They have apprehended 4 persons from Jharkhand and conducted search of their luggage in presence of witnesses and recovered 1 piece of suspected gold in both shape weighing 1.853 kg and 1 small size steel sewing frame with 4 pieces of small size sewing blade hacksaw. And sees the same preparing scissor list. And the selling party escaped from the place of occurrence, and during preliminary interrogation of the apprehended person, the apprehended persons have shown the houses of the seller, whom later on identified as Rasidul Haq, Moqsidul Islam, Nurul Hussain of Bliss, Kanuamari Kolampar, Nagaon. So, what is your case, Mr. Abdullah?
My case is there, there's some imitation gold were recovered from some other person. And they knew that it was imitation gold, but we have the 420, 406 may not be accepted because I have not cheated anybody, I have not cheated anybody, And they knew, they came from Jharkhand, they knew, that these are imitation gold.
Mr. Abdullah, learned counsel for the applicant, submits that though the case was registered under section 120B 406 420 34 IPC, yet the offense under section 406 is not made out.
Not made, and 420 also, because cheating may not be
For
done. I have not
406 420 IPC are not made out against the present accused persons, and nothing has been recovered from their possession, and they have also not found in the place of occurrence, and they are ready to cooperate with the investigating agency, and therefore it is contented to allow this petition. Whereas Ms. N. thus learned additional PP has produced the case diary before this court and submits that the IO has collected some materials in the case diary in support of the allegation made in the FIR, and therefore Ms. Das has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case diary with the assistance of Ms. Das, learned additional PP. So, madam, can it be said that section 406 420 IPC is made out against the accused persons, present applicants?
Lordship, they are the habitual lordship.
Habitual offender. But whether any victim statement of any victim has been recorded by the IO? No.
Victim
Then
statement.
how can you will establish the case? Because only on the basis of the statement of the co-accused that they are involved in this kind of business.
Lordship, one bail objection is there.
Pardon?
One bail objection is there. Lordship. No statement of victims are there. Lordship.
Habitual offender of the locality, what cases have been are pending against them? What are the number of cases?
We have not reflected it in the
Then
case diary. Lordship.
how do you justify it?
Lordship.
The case diary indicates that except the statement of the co-accused, the IO could not collect any IO could not collect any materials in support of the allegation made in the FIR. Having regards to above and also having regards to the nature and gravity of the offense, this court is inclined to allow this petition. It is provided that in the event of arrest of the applicants in connection with Samaguri PS case number so and so under section so and so, there shall be enlarged on PS bail on their executing a bond of rupees 50,000 each with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, they shall not leave the jurisdiction of Chief Judicial Magistrate Nagaon without prior permission. There's a relator.
Item 21.
And 22 law was listed on the day before yesterday, and
in fact, that was disposed.
Mr. Deka,
Yes, Lordship.
on the other day, you have not uttered a single word that on 2 occasions bail petition was
I have
rejected
submitted,
earlier.
Lordship. After twice rejected, I have clearly submitted, Lordship.
When?
On that day, Lordship.
No.
Lordship, I have submitted, Lordship.
No.
I have submitted after twice rejected, this application was filed.
No.
And in fact, my learned friends have also while objecting the bail application stated that twice.
On that day,
Mr. Parasor, did you point out that this
Ma-
court has earlier rejected
Malad-
bail petition of the accused person?
on that day, this is, I don't know, 36 and 37. 37, I have not said mark, 36 was second. 36 means this 21. This item second. I have not said twice, but I have said earlier rejected. I have.
No.
Yes. But, otherwise, I have objected regarding the.
You have objected, but you have never
have
pointed
clearly
out the earlier orders.
I have clearly submitted, Lordship, in the first instance, Lordship, after rejecting twice, this application was filed.
No, had it been pointed out, definitely I would have asked what is the ground for filing this third application.
Lordship, in the first occasion also, Lordship has
No,
made a
now
query.
you tell me what is the ground for filing this.
Earlier application was rejected on 2022. That is 10 months before, Lordship. So after that, Lordship, the investigation has progressed, and at that time, investigation was the drawing on, Lordship. And the motion they also, Lordship, made a query about that, Lordship.
What?
While issuing the notice, Lordship has made a query, what is the new ground? And on they also I have submitted. And the last order is of 2012-2022.
First rejected on 25th of January 22. Second time is 20th of December.
First was rejected immediately after the case was registered. Second one is rejected on 2012-2022.
Now, what is the stage of investigation?
Investigation, substantially progress. One fact is that one technical expert, there's opinion is there that these are the PDS types. Technical expert of FCI. And from the
what is that report?
Report is that as per the report, the rice government rice received from Punjab region is being issued to PDS. That is the report of the dated 13/12/21.
So it is confirmed that the sales rice or PDS rice.
PDS rice, and it was total 330 quintals. 660 bag. It's 50 kg recovered from the shop of this petitioner. And he, in his confessional statement, he was appeared after 141 notice. He appeared before I. He, in his statement, he stated that some local person who received the PDS rice, they exchanged this rice and with boil uha rice, and these PDS rice here stock some customer from Tura Meghalaya, they come and he supposed to sell those rice to that person, and total 330 quintal PDS he also confessed. But yes.
Now, what is the stage of investigation?
Suspect not yet file, but several witness also examine Caesar witness and substantially progress but suspect not yet file.
Okay, we will submit the case then.
Well,
so your ground is only delay.
Yes, a delay and also investigation has already been completed, Lordship. And during pendency of this bail application, 41A notice was issued.
and they appeared and submitted the voucher by which they have purchased the rice from the local market. And the investigators again are going to come to the PS laws. So therefore,
So their statements are available in the case diary? Available.
Statement of the petitioner, yes, available.
Okay, we'll say you submit the case diary.
And in the other case, 22 deer is 98 quintal.
Timing item 18.
Lordship, yesterday, Lordship, I have a telephonic instruction, Lordship, I have received. Lordship, Lordship, the IO needs to 1 week to verify that Lordship, the cell did Lordship.
IO?
Lordship, one week Lordship needs 1 week Lordship to verify the cell did Lordship.
1 week.
Lordship. Next week, Lordship. One report from the circle officer, Lordship, they have not received regarding the verification of the cell date, Lordship.
So when
Whether
you
the
will
cell
be
date-
able to produce the report?
Next week, Friday, Lordship.
Next Friday? No, not next Friday.
Wednesday.
Wednesday.
My lord, I have a submission, my lord. In this case, my lord, total section are, my lord. Number one, my lord, section 4, Prevention from Money Laundering Act, my lord. Later on, various prayer of the IO, learned citizen deleted or moved the section Money Laundering Act, my lord. After that, my lord, section, my lord, 420 and 413, my lord. 14, my lord, cheating, my lord. 413, my lord, deliver the stolen property, my lord. It's a money, my lord, simple case, my lord. The view of the case, my lord, at general checking, Naka checking, my lord, that amount was seized by the IO, my lord, from this prisoner, my lord. That day, my lord, from that day till today, my lord, 11 months, 3 days already completed, my lord. In this heavy period, my lord, the investigation is not completed, my lord. Whereas, in this section, my lord, the time of the charge sheet filing, my lord, only 2 months, my lord. Running is, my lord, 11 months, 3 days also completed, my lord. Till today is going on, investigation is going on, investigation is going on.
So one last opportunity we will grant to them.
My lord, Krishna
We
is
will,
suffering various problems, my lord, because due to close his the grocery shop, my lord. That is the earning source only, my lord. He is a by profession.
No, that's
He
all
has a
right,
family
but
member.
it is better for you also to settle the
Yes.
matter once for all.
Apart from that, my lord, from that day till today, no anyone case has been filed against this petitioner and against this Caesar money, my lord. Absolutely, ultimately, absolutely honor, my lord.
No. Whether any case has not been registered?
No, my lord, no any other case against this petitioner, my lord, in this regard, my lord. Six money, my lord. No case has been filed, my lord.
No, this Gauripur PS case number 4.
Yes, my lord, I am the owner. That is, my lord, I am the owner. In this case, my lord, in connection with this amount, my lord, no one person, my lord, can in front of the IO, my lord. Ultimately, I am the owner.
If it is established during investigation that you have acquired the amount by selling your land,
yes, my lord.
then there will be no case against you.
Will be track also, my lord. Full Punjab will track also, my lord.
So wait for 2-3 more days. Ms. Enders learned additional PP submits that she may be granted some more days so as to enable the IO to complete investigation in respect of the so as to enable the IO to verify the sell date from the office of the circle officer of which place?
My lord, Gologan circle. Under
Gologan circle.
My lord, not a sell date, my lord, sorry, my lord. It is an agreement. First, Baina Bata, that is called Baina.
Agreement. Okay. Agreement, not sell date. Pair of Ms. Das is accordingly allowed. leaves the matter on Wednesday. No further opportunity will be afforded to the to Ms. Das, learned counsel for learned additional PP in this regard.
I will.
Pending item 13.
Lordship, in the affidavit, Lordship, accused petitioner has stated, Lordship, the three numbers of transaction. One for his salary, 2,40,000 for the year 2021-22, 22-23. And Lordship, another what the payment made to the earlier secretary, who is the father, the 4,80,000, and who died in the year 2021, 6/2021, as per the record. Now, Lordship, in the case diary, it reveals that there are many transactions are there. I'm not calculating the entire transaction, but Lordship, here we find that it is a bank account of the cooperative society, which is run by the secretary himself, is a own. And there are many transactions before 2021 also. From 18 also 20, there are many transactions are there to the bank account. I'm not calculating the same. So Lordship, kindly produce the record. I have tag marked all the transaction where the
No, you find out whether it is consistent with the document placed by him in page number 78.
Lordship, here the 70 it is counted from the 2021, but from the case diary it is counted from the 2018. So if we are not calculating from 2021, from the 2018 to 2020 also, there are various transactions in the name of the secretary.
Yes, Mr. Ali.
To that effect, my lord, resolution page 59 is there. The governing committee took resolution, my lord. There is a two account, my lord, one joint and one single. Single account for, my lord, speedy recovery, my lord. This is, my lord, from 2016 onward.
As per FIR,
Lordship.
only there was only one account.
Yes, my lord, that is not correct, my lord. There is a two account, my lord, one joint account, one single account, as per resolution, and they are running from, my lord, 2016 onward. This 59, my lord, resolution. This 60, my lord, resolution number. Regarding, my lord, office running from home, my lord, earlier complaint was made, it was investigated by the register office itself, my lord. They submitted report, there is agreement because the office has been, my lord, damaged. Therefore, they entered into agreement with the, my lord, father of the petitioner, they are running office. I am furnishing the copy, my lord.
Yes, okay, we will see.
Completely internal, my lord, and this FIR has been filed, my lord, the newly elected body, and this one court, my lord, said aside the election.
You submit the case diary
Lord.
and the relevant pages of transaction in the
Yes.
statement of account.
Yes, Lordship, I have already tagged and underlined.
Pending item 8 and 17.
Diploma.
So the contraband substance recovered in your case, it is not a commercial quantity.
No, it's a intermediate, my lord. It's
Intermediate
30, less than 30. Less than 30, because there were two packets, two parcels. One is 95, another is 97. So 95, so far as 95 is concerned, my lord, there was a phone call which was received from Tirupati courier to Amit Jain. The number has been given. Amit Jain, my lord, who was granted bail. So he received a call and he told me that there is one a parcel which has came in your name. So I went along with Amit, along with me has gone to Tirupati Courier Service. We went there and said this parcel number 95, which belongs to you, my lord, it was handed over. Immediately they have taken over, the NCB.
So you are behind over since 26/9.
Yes, 52
For
days.
how many days?
52 days as on date.
52 days.
52 days, man. Amit Jain, Amit Jain, Amit Jain, 26/10/2023. Amit Jain.
He has been granted bail.
Only learned trial. He has been granted bail. 26/10.
So there remains only 8 days to complete
Yes,
the
that's
statutory period.
it. And
Yes,
my lord,
Mr. Kai.
it is 30, and there is one. Along with plastic pouch, it is 30 grams. Along with plastic, 30 grams. Maybe less also. Maybe less.
Yes, Mr. Kyle.
See, admittedly, this is intermediate quantity. But see, with respect, there are two bail application. One with regard to my senior friends. His name is Vedanta Das. But see, the case study reveals that the parcels containing some telephone numbers and the address was there.
I'm sorry for disturbing. I should point out one thing before Lordship. There is your Lordship, why it didn't came from my side, before my learned friend. It is only based on section 67. There is a statement which is given by Vedanta 67, stating that amount of 55,000 was sent to the consignor on the basis of statement given by 67. That's only there, but that particular consignor was never examined. Nothing, man. So this is, I have to bring notice 67 of the end. This is which your Lordship also I show an order. It is not admissible. Lordship is aware of it, and there is an order passed by this court. Before my learned friend starts off, kindly see this order of your Lordship. I think that's very clear where your Lordship has passed this order. Only one order I will show it, my lord. How your Lordship dealt this particular case. Then my lord will kindly hear my learned friend, my lord. This is also 439. My lord, the 5, my lord. Mr. Bora, learned senior counsel, accused was arrested on 13/9/2023, and since then he has been languishing in jail hazard. Mr. Bora submitted quantity of contraband recovered from possession of the co-accused are of intermediate quantity, and except the own statement of the accused recorded under section 67 of the NDPS Act, and also statement of the co-accused, there is no material whatsoever to show his complicity with the offence alleged, and nothing has been recovered from his possession. Referring to the decision of this honorable court so and so, Mr. Bora submits statement of the no longer admissible against other accused. Submit nothing has been recovered from the possession of the present accused, and that the main accused, that is two Nigerian nationals, from whose possession the contraband substance recovered have already granted default bail by the learned trial court, and that the accused has already cooperated with the investigating agency, and therefore Mr. Bora contented to allow the petition. On the other hand, Mr. Kyle so and so, there are sufficient material to show complicity of the accused with the alleged offence. Number 2, that there is nothing has been nothing has been recovered from the possession of the present accused. Yet there is a statement of the co-accused beside his own statement recorded under section 67 of the NDPS, that the contraband substance so recovered from the was meant for the present accused, that the contraband substance so recovered from the possession of are cocaine, and the two accused hails from Nigeria. There is an international link in reporting the same to India. Investigation in that angle is being carried out. I have contended to dismiss the petition. Now, my 8, it appears the accused were arrested in so and so arising out of Panbazar PS under section 22B of the NDPS read with section so and so. He has been languishing in jail hazard. Initially, the case was registered and so it was handed over to NCB.
involvement of foreign national in international link and ramification. Indisputably, nothing has been recovered from the possession of the present accused. He was arrested on the basis of a statement beside his own statement. And admittedly, all statements of the co-accused is no longer admissible in view of the decision of the Honorable Supreme Court in case of so and so. Same is the position case of statement under section 67 of NDPS Act. Also, Bora learned counsel accused rightly pointed out during his argument. Further, it appears from the case that investigations of present accused concerned is almost completed and appeared on several occasions before the IO. A statement was recorded. He has been languishing in jail hazard for last 20 days, and his further custodial intention in the interest of investigation seems to be unwarranted. Herein, in this case, though Mr. has submit that the international link in importing the contraband substance of India, the said link has to be entered into it. Appears the case was registered long back and IO got sufficient time investigating into that angle. Present accused is a local resident, as such there is no scope of jumping bail. So and so, considering the facts of the some of the co-accused have already enlisted on bail, this court is inclined to extend the privilege of bail is to the accused. Now, my lord, in this case, if your lordship kindly see the order of Amit Jain, kindly see the order of Amit Jain, my lord. This is very important, my lord. Kindly see, my lord, 26/10/2023, who accompanied this petitioner, and phone call received by Amit. Learned counsel, next page, my lord. Learned counsel appearing for the accused has submitted the accused person has no connection with the case, as his accompanied was Vedanta Das, who received a parcel from Sri Tirupati Courier Service. When Vedanta received the parcel, then the NCP official arrested them in the case. Learned counsel further submitted, nothing has been recovered from the constructive possession of the accused person. It has been submitted. Further, the accused Amit Jain does not stand on the same footing with the other accused because he does not deal in any contraband and did not make any payment for consignment, as it appeared from the statement given under section 67 of the NDPS Act. Copy of the statement has been enclosed. It is further submitted that accused a local man, and in the event of allowing the accused to go on bail, he will cooperate with the investigating of the case. On the other hand, the NCP has filed written objection against the bail filed by petitioner Amit Jain in his voluntary statement under section 67 of the NDPS Act, stating that he has knowledge of the parcel containing cocaine, have inquired telephonically about the parcel destined for Vedanta Das from the office of the Tirupati Courier Service, and also accompanied the accused, namely Vedanta Das, to collect the parcel. Now, kindly see, it is further stated, total 65 grams suspected cocaine, which is an intermediate quantity, has been seized in the instant case, and chemical examination report is yet to be received. If the bail is granted to the arrested accused person, Amit Jain, there is every possibility that he may jump bail, may involve himself in similar nature offense. So IO has paid for rejecting the prayer of the bail of the accused. Now, I have gone through the case record and photostat document submitted along with the bail petition, and it revealed accused has been in jail custody since 28/9/2023. Total 65 grams suspected cocaine is which is an intermediate quantity has been seized in the instant case. The case is related to 20B so and so. Having considered the stage of investigation, or Lordship kindly know, I am of the view for the purpose of investigation, further custodial detention of the accused, namely so and so, if he cooperates so and so.
Okay, okay.
My lord, I will not trouble my lord.
Yes, yes, Mr. Kyle.
Lordship. Lordship, facts of the case. Lordship.
Pardon?
Facts of the case. Lordship, there are two applications with respect to my senior Vedanta Das. Lordship, the case diary reveals that on the specific information, the NCB team search the courier service, and where the petitioner along with Amit Jain were there.
No, that's all right. Facts is there, but whether his further custodial interrogation or detention is required, he is already
No, Lordship,
52 days in jail hazard.
Lordship, to refer to the
co-accused have already been enlarged.
no, Lordship, he was on different footing. Lordship,
How?
here, because Lordship, may please to see, because I am submitting from the case diary. The consignment which was seized from the courier in the hands of the Vedanta Das virgin petitioner, that was containing some telephone number, and an inquiry it was found that that mobile number was sent in the name of Vedanta. Lordship, this is the objection filed by the NCB before the Landed Trial Court. Lordship, this is paragraph 1 and 2.
Here's the address of the accused. Who is accused?
Lordship, present petitioner.
Acha. Vedanta Das.
Yes, proof is there in the record.
What is this subscriber detail report?
Yes, it is there. Listen. And Lordship, in the meantime, FSL report also come. That is the positive sign of the. That report is also there. At the relevant time, it was not there. Lordship, I flag mark the relevant papers. Flag mark 1 is the.
No, that's all right, but whether further custodial detention is required?
Lordship, in case of NDPS, Lordship probably.
No. Had there been a section 37, then position would have been different. Here, there is no.
In case of intermediate quantity, Lordship, 37 will not come into play. It's my learned senior has placed one judgment. Actually, I was there in that case. Lordship, that the facts of that case was quite different from this case. In that case,
which case?
That judgment placed by passed by your Lordship in case of one Pulkit and
yes.
In that case, Lordship, what happened? For 1 year, Assam police arrested some 19 people, and they were allowed to go on default pay. Thereafter, the case was handed over to NCP. Then NCP, while investigation, they arrested 2 persons after 1 year. And nothing was recovered from them.
No, Mr. Das has referred it only to support his contention that section 67 CRPC is not relevant.
With respect to 67, Lordship, I have a submission. In paragraph 153 of Tufan Singh, Honorable Supreme Court clearly said that although the statements are not admissible under section 25 of the evidence act during during the trial, for investigation, Lordship, there are so many judgments where Supreme Court says that for investigation, that bar will not come into play for the purpose of investigation in filing of the report. Thereafter, Lordship may consider. And Lordship, I want to place one paragraph of judgment of Honorable Supreme Court in case of Hira Singh, paragraph 8.5. Otherwise, 37 is not applicable.
But your Lordship refers to a case in this judgment. Samarth has been referred. Samarth Kumar has been referred. Your Lordship kindly see in the judgment, Samarth Kumar was referred. Why, my Lord? When the Tufan Singh was cited, 2, my Lord, in that case, 2 was granted advisory bail. 2 was granted advisory bail on the basis of the advisory bail judgment by Indra Banerjee, my Lord. 2 was granted. So the person who was languishing in jail, he got the benefit. So they went for cancellation. Court said that 438 is different. But 439 was languishing, that may be he can argue the case. So far as he can take the advantage, not those 438. I am languishing. That's what the judgment makes. That's why your Lordship referred to a judgment of Samarth Singh, my Lord, Samrat Kumar, my Lord. Kindly see, my Lord. After Tufan Singh, that may be an appropriate case where he can take the benefit under 67 because he is always languishing in the jail. 52 days, my Lord, all investigation is complete, everything has been found. Just keeping, my Lord, is an intermediate less than 30, my Lord.
So, whether offense report was submitted?
No, it is Lordship.
No, you have collected the FSL report also?
Yes, 24th is the last date.
Then what remains to be investigated now?
No, Lordship, probably this question will not come into play in case of NDPS cases, in my humble submission. And there are so many judgments. After that, my learned friend is submitted. We can say that some other views were taken by the Supreme Court in interpreting section 67.
Tufan is a larger bench.
Yes, Lordship.
Then
No, Lordship. Thereafter, in different cases, and my learned senior has referred one judgment where 3 persons probably were there. They were granted bail by the Karnataka High Court. But in case of 2, Honorable Supreme Court has upheld the order of the hearing, but only in case the bail was cancelled. So there are different judgments on interpreting Tufan Singh law. And Lordship, I am placing another judgment that is from Meghalaya High Court, just for purpose of what is the purpose of NDPS Act? Paragraph 22 and 23.
No, you forget about the judgment of Meghalaya High Court.
No, Lordship, just for
What a recent trend of Supreme Court is, you know about it.
Yes, Lordship. Lordship, there are so many judgments. I have also with me. I don't want to burden your Lordship, but simple thing is here. In present case, Lordship, there is no applicability of section 37. But the Lordship, the facts and circumstances, because drugs were seized from the petitioner, it is admitted fact. And it has appeared on the partial also. And with respect to item number 8, this her plate was searched and contaminant were recovered. That is, this is the report.
And in that case also, the contraband substance are of intermediate.
Yes,
all was arrested.
And it is rather available, my lord, because 5.33 grams and small quantity is, my lord, 100 grams.
No,
So,
1
my
gram.
lord, 5.33 grams.
Yes, it is 1 gram.
100 grams.
No.
Charas.
All these 4 were arrested.
Available.
My lord, all these 4 were arrested. 2 was granted and 2, my lord, that's why we approach this on the same footing, my lord. And all is, my learned friend said FSL is there. All has been examined. What remains for further investigation? 52 days I am languishing.
No, in case of Mr. Das case also, he is behind the bar for 52 days.
Same day, on same day they were arrested.
I'm a girl, my lord, 30-year-old girl. I decided.
Lordship, the facts of the case is very bad for my learned friend also. Lordship, pleased to see her on the information his plate was searched, her plate was searched, and from there Lordship contraband was seized. I have submitted the report submitted before the learned friend. Lordship, please peruse that.
Okay.
Yes. Lord, this particular accused person, my lord, is a girl, my lord, and she stays with her fiancé, my lord, where from the contrabands were seized, my lord. It was, my lord, 5.33 grams of charas, my lord. And that is, my lord, the small quantity is 100 grams, my lord, and that is below small quantity. So otherwise that is bailable, my lord. And, my lord,
below 100 gram, it is bailable.
my lord, charas, it is 5.33 grams.
Yes, Mr. Kyle, anything? No.
Lordship, case diary is before your Lordship. And Lordship,
Okay, I will go to the case diary. What's necessary? Pardon?
Lordship, paragraph 8.5 of that judgment.
8 point?
8.5.
Okay.
Only what I am saying, my lord, the ground rejected and Amit Jain was granted bail. Was that Amit Jain also the objection raised by them is a jump, he may jump the bail. He may jump the bail, similar offense he may do it. That's what the argument of the NCB before the London Trial Court. In spite of that was it. And my rejection was this, they jumped the bail and 67 miles. That's all. Deeply obliged, my lord.
In my matter, my lord, item number 8, my lord, there is schedule, my lord, cannabis and cannabis resins with charas and hashish. A small quantity is 100 grams and commercial quantity is 1 kg.
100 gram is small quantity,
My lordship.
not
And-
intermediate quantity.
There are two
Not
sub-
intermediate.
Not intermediate.
Two
100,
substances were seized from plate of the prisoner.
one is tobacco. If my lordship may kindly
Allow me to place that, my lord. Page 20, my lord, is the Panchnama. My lord, here, my lord, it is during house search. 3 plastic packets containing suspicious substances believed to be charas were recovered from wardrobe almirah. A wardrobe, a small quantity, page 20. Third para, my lord, last 2 lines, my lord. The search of the house started at 17 hours in front of both the independent witnesses and owners, occupants of the house, namely Deepak Bhatia and Bilki Sami. Deepak Bhatia has been granted bail by the Honorable Court considering that, my lord, his custodial detention is not necessary for the purpose of investigation. And during house search, my lord, 3 plastic packets containing suspicious substance believed to be charas were recovered from wardrobe almirah. A small quantity from each packet was taken out and tested with the help of DD kits, drug detection kits, which gave positive result for charas. After that, weighing of the contraband down and found total 5.33 grams. And the other substances which my learned friend is, my lord, pointing out, my lord, that page number 22, my lordship will find. Search cum seizure, brown color substance contained in pouch believed to be charas 5.33 grams, and other is tobacco, my lord. This is two things only, my lord. Subsequently, my lord,
No,
if my
is
lordship may
tobacco a contraband substance, Mr. Kyle?
Lordship,
Tobacco?
Tobacco is not
Contraband substance.
Tobacco is not a contraband substance. Although it is fall in the category of drug, but not contraband.
Then my lordship may kindly come to page 57 for a moment, my lord. Page 59, my lord. Fourth parameter. The person, my lord, this my lord, the person with whom I stay, my lord, he has been granted bail. Page 59, my lord. Fourth para, my lord.
Deepak Bhatia.
Yes, my lord. I have meticulously considered the materials available in the case diary. After perusal of the case diary, I am of the view that further detention of the accused person is not required for the purpose of investigation. So, my lord, the Amit Jain, he was granted bail considering, my lord, the stage of investigation. Then Deepak Bhatia, my lord, his bail has been considered, considering that his further detention is not necessary for the purpose of investigation. And these two accused persons, my lord, they are behind the bars. For a moment, my lordship may kindly query as to whether any interrogation has been done behind the bars till from the date, my lord, from 28/9/2023 till today, my lord.
Okay, we will see that case diary is available before the court.
My lord.
We will examine.
My lord.
Lordship, rejection order is page 39. Let me also.
And one more, I have well, one more pair, my lord. The present petitioner, my lord, she is a girl, my lord. And my lord, in the court below, I had taken one more, my lord, ground that proviso to section 437, my lord. That, my lord,
we'll look into
that deeply obliged, deeply obliged.
Lordship, I have one hearing matter. If Lordship, I want to do on Monday also.
Today?
Today, item number
14,
14 and 15.
for hearing.
Maybe taken on Monday also. Yesterday, I could not because due to my
Oh,
call also.
acha. Mr. Mozumdar. So he paid for adjournment.
On Monday,
Monday, this court will not be available. Only in the first week of December.
Because I was suffering from cold and fever yesterday.
Okay, that all right. In the first week of December, then.
Lordship, appellant is in custody, Lordship.
That's
And
all right.
already
But
more than-
what to do if he is not
8.5 years, Lordship.
Pardon?
Or 8.5 years already, Lordship. And there are 10 years sentence. They
Oh.
will consider.
But without hearing the other side, I cannot deliver the judgment. Problem is that Mr. S.C. Kyle, learned standing counsel for the NCB, submits that he is he is suffering from cold and fever, then unable to argue the matter and pays for listing the matter in the next week. Here is accordingly allowed. Rest is the matter in the first week of December.
Much.
All right. Lordship, any date? Any date?
Any data.
12 December.
Well, short date or first week.
Seven.
7th of December.
7 December.